I am thrilled for Open Medicine Foundation to present this webinar that we have called The Nuts and Bolts of Applying for Disability Benefits in the U.S. if you have a disabling ME/CFS or long COVID.
We are going to present, that is Barbara Comerford, an attorney in New Jersey, and I am Gudrun Lang, a neuropsychologist in New York. We are going to present a webinar this morning on the nuts and bolts of how to apply for disability benefits if you have disabling ME/CFS or long COVID. We came to think about a webinar like that in conjunction with Linda Tannenbaum from the Open Medicine Foundation, because at times I am confronted as a medical professional with questions about long-term application issues and long-term issues in general. And since I'm not a legal scholar or attorney, I am not comfortable answering them many times. So Barbara agreed to address some of the most common questions in this webinar, and I'll hand over to Barbara.
Yes, hello everyone. Dr. Lang and Ms. Tannenbaum and myself decided that this webinar might be very helpful for people viewing the Open Medicine Foundation website. Commonly, I get questions, as Dr. Lang gets questions, from people affected with and disabled, frankly, by long COVID, ME/CFS and ME/CFS. What happens in these situations is people begin to realize that they are limited in their ability to work, and they become frightened, and their ability to support themselves becomes compromised. Now, before we start, one of the things I want to say is that no two cases are exactly the same. What we are doing here today is giving you a general framework of what many plans say, what many fact situations consist of, and what many common complaints and questions people have are. So by no means is this an exhaustive treatment of long-term disability and ME/CFS or long COVID. It is simply an overview that we hope proves very helpful to you in navigating a very frightening time of your life. So Dr. Lang, would you like to begin our questions?
Yes, I will. We have organized this webinar into 3 parts. The first part is decisions that need to be made before you go on disability. The second part is what questions pop up when you are on disability. And the third part is to what happens when you've been on disability. So I will post questions to Barbara that I have collected, and Barbara will address them in brief talking points, and then we'll summarize the key elements of those talking points, the key points, once again at the end, so that people who have a little bit of a hard time because of cognitive limitations will be able to understand and absorb the information that we will be giving. All right, here I start. So the first question in the content area of decisions that need to be made before you go on disability. Question is, if my health condition is affecting my ability to work, what is the best way to try to obtain disability benefits, Barbara?
Well, yes, thank you, Gudrun. Oftentimes what happens, people will call me and say, you know, I'm beginning to feel challenged physically and cognitively, and I'm not sure what the best way to proceed is. One way may be to take vacation time that's available to you to test out the waters. Another way may be to use some personal time off. PTO is very common these days. Or another thing is sick time. The worst thing people can do is resign. And I say this because if you have a long-term disability policy, through your employer. If you resign, you are not actively employed, and actively employed means that you have to be at work the day you notify the employer that you're going out on disability, because if you are not, you will lose your right to those benefits. The other thing is FMLA. Oftentimes what employers, particularly large employers, will insist on is that you file for Family Medical Leave Act absences, which means that you're notifying them that either as a result of a disability that's affecting you or a member of your family, but in this case, it would be you, that you're having a challenge working. They will ask for a doctor's note. They will to support the disability, and then you'll have 12 weeks, usually unpaid, but they usually consume that time with either sick or vacation time. And that 12-week period is a time period that I frankly counsel people all the time to see if they can get their sea legs back. Is this just a bad CFS exacerbation or a bad post-COVID reaction? Or is it more than that? And in 12 weeks, you'll know. One of the things we tell people all the time is familiarize yourself with the terms of your employer disability plan. You want, and frankly, health insurance plan, because you want to know whether or not, first of all, how you go about doing it. Some employers require you to notify them after 5 days of absence that you're going to be filing for short-term disability, which precedes long-term disability. And they have very specific instructions on how you do it. So be familiar with what your plan requires. The other thing you want to be familiar with are deadlines. Do you have to notify the employer within 5, 10, 15, or 20 days, 30 days of your intention to file for short-term disability? All of that is by necessity in the employer disability plan. Under the Code of Federal Regulations, they have to provide you with the notice of when those disability have to be told to the employer, what the time frames are, and it's important to follow them very, very strictly, because if you don't want them using that as an excuse to deny your claim. The other thing is you want to see what the definitions say. You want to see what their definition, what the plan definition of disability is. Do you have a disability that you have to document you can't perform the duties of your own occupation? Do you have a disability that says you have to prove that you can't perform the duties of any occupation? All of that has to, under the Code of Federal Regulations, which governs ERISA, which is the Employee Retirement Income Security Act, which governs all of these employer plans, all of that is spelled out in that document. So familiarize yourself with the document. The best way for you to go, in my opinion, is if during that 12-week FMLA period, you're not getting any better, and you know that it's not just a simple exacerbation, that it's going to be a prolonged exacerbation. Your best bet is to file for short-term disability. Do not, under any circumstances, resign. I'm begging you. It will cause you to lose your entitlement to benefits, which were a perk of the employment, which is crazy to just give up, because often the short-term disability can be 2/3 or even 100% of your pre-disability salary for a certain period of time. With long-term disability, it's often 50 to 70% of your pre-disability income. So throwing those benefits out the window is crazy. You also, and this happens with me a lot, I get calls from people all around the country where our headquarters is New Jersey, but we do these disability cases all around the United States. And I will get calls from people saying, well, I'm not sure. I don't think I'm going to be able to go back to work. What are your thoughts? That consultation in my office is free. And frankly, most disability law firms will give you an initial consultation for free. Don't be foolish. Reach out to an experienced disability lawyer and ask them, tell them the facts of your case and ask them what their advice might be for you. It'll be well worth the time you spend. The other thing is, we want to go over briefly the differences between the different types of long-term disability insurance policies you have. pardon me. If you have a group disability policy with your employer, it's governed by ERISA, Employee Retirement Income Security Act. It's a federal statute that was created to protect workers. Frankly, it was initially passed to protect workers from pension raiding by dishonest employers and unions. Now it's often used for protection of these disability and pension welfare benefits and pension benefits. ERISA long-term disability is not a vested pension benefit. It is a welfare benefit, and as they give, they can take away. So it's very careful to follow the strict guidelines. The other thing is you can get ERISA group benefits through a professional employment association. So let's say you are a flight attendant. Flight attendants may have a flight attendant association, which offers long-term disability. Teachers commonly and other professionals commonly have their own disability group plans. And so if you belong to a professional association of any kind, you always want to reach out to them and ask them if there's a disability, a long-term disability policy connected to your membership. I know attorneys have it. Attorneys have it with the American Bar Association. The other type of long-term disability policy is one you purchase by yourself. You either get it through a financial advisor, or perhaps, you've just known people who are brokers who were reaching out to you, perhaps when you were younger, and said, you really should have this kind of coverage. It's tax deductible. It's a good idea. Those policies are policies that you own yourself. ERISA does not come into play. And we're going to get into a little bit more about ERISA later on. I don't want to confuse you at this point by getting into it in too much detail. One is through employment or a professional association governed by a federal statute. But when you buy a disability insurance policy through a broker or financial advisor, they're called disability income policies. Those you own, those you have bad faith protections, which you don't have with ERISA, and you are governed by state law. But again, it's crucial to read your policy and see what deadlines are in the policy, see how they define disability, see how they define proof of loss. All of those are extremely important, just like the other policies. The other thing we're going to touch upon today is SSI and SSDI, Social Security Disability or Supplemental Security Income cases. If people have contributed FICA taxes, that's that big chunk of money that comes out of your paycheck every time you get paid, that funds the Social Security Trust Fund. The Social Security Trust Fund has certain requirements. And one of the requirements for SSD, Social Security Disability, is that you contribute, generally speaking, 20 out of 40 quarters of coverage. And that means 5 out of 10 years of your employment, you have to have contributed to the Social Security Trust Fund with FICA tax. Now, what that means is people in the old days, when I first started practicing in this area, you had to actually work every quarter of the year for that quarter to be covered with FICA taxes for all 4 quarters of 1 year. That changed about 20 years ago. And what the government said at that point was, look, if you contribute X amount of dollars over the course of the year, we will consider you covered for the entire year. For 2023, I have to look at that, but I'm not exactly sure what the maximum, but it's a low threshold. It's not much more than like $10,000 for the entire year. So if you earn that during that entire year, you're covered, which is a wonderful thing, because people who were sick would struggle to continue working till the end of the year just to have contributions for each quarter. And it was crazy. It made no sense. And even Congress agreed with us. So Social Security Disability requires you to prove that you're totally disabled. With the ERISA plan, disability plans, and the private disability insurance plans, often you have to either prove that you cannot perform the duties of your own occupation, or that you cannot perform the duties of any occupation. Social Security, it's the same across the board. You have to document that you cannot perform any duties in any substantial gainful work activities. That's a term of art. We'll get into that a little bit later, but basically that you can't work. So if you're working, you have to prove that you haven't worked for 12 continuous months, or that you're expected not to be able to work for 12 continuous months. And you have to have documentation from a medical professional. It's not enough to say, and I get these calls all the time, I just don't feel good and I haven't been to work in 2 years. What did your doctor say? Oh, I can't go to doctors. They freak me out. They're well, we have to have that because that's what the regulations require. So you have to document that at some point you cannot work continuously for 12 months as a result of your medical impairment. The other thing is SSI is welfare. So that doesn't come out of general treasury funds, and you don't have to have any work history with it. But it's because it's welfare, you have to document that you're impoverished and that your income and assets fall below the poverty lines. With SSDI, you have to meet those threshold requirements for contributions, FICA contributions for 5 out of the last 10 years. The only exception to that is if you're under 30 and there's a whole formula that they place. It used to be that you just had to earn half of the credits someone over the age of 30, but with all the modifications and changes in Social Security disability in the last few years, they've the closer you get to 30, the more credits you're required. The lower it is, the less credits you require. The key points that we wanted to make is just know your employee benefit plan or private disability plan, or, the requirements for Social Security disability. The second key point is you want to get all the documents you can from your employer. One of the things I tell people is the minute you start feeling ill and you're not sure if you can continue working, immediately, if your employer has online access to ERISA documents like health insurance, because sometimes if you qualify for long-term disability, they'll continue you at an employee rate on your health insurance. So it's not just the long-term disability plan that we require to review or you should look at. It's also what health insurance and what other welfare benefits do you get if you qualify for long-term disability? And those are really important. They don't sound like they're important until you get closer. You've gotten closer to approval, and all of a sudden you're getting notices that you have to pay these huge COBRA benefits. You have to pay huge COBRA premiums every month. And suddenly when people start saying, oh my God, I have to pay a couple of $1,000s a month just to continue my health insurance. Sometimes no, sometimes the plan will say, once you qualify for long-term disability, we will underwrite the cost of your health insurance by continuing your health insurance at an employee rate the way it was before you got sick. Not all plans say that, so I have to caution everyone. Everything I'm saying here today are generalities and are sometimes available in some plans and others not. So that's why you need those plans to figure out what benefits you have and what you don't. Because trust me, employers won't always tell you. If you don't ask, you won't get. And the best time to get them, because as most people know, they'll shut you out of an employer portal the second you file for disability. And once you're shut out, you can't get those documents anymore. So the minute you suspect you may need to be looking at all that, download it. Ask questions later, but download it. The other or just ask, sometimes people don't have, if it's not a real large employer, they may just have a summary plan description, or they may have some kind of written materials, whatever. Then just take the chance and ask your employer if you can see those, just so that you're familiar with it. It may tip them off, but you're better off having it if you know you're going downhill fast with your health. Yes, and as we said, you want to, and the other thing is people buy private health insurance, either through a financial advisor or a broker, and then 20 years passes, 10 years passes, and they can't find their policy. Insurance companies have an obligation to keep those policies. So what you have to do is give them a call, tell them you need a copy of your policy. They'll usually charge you like $25 and it'll take a couple of weeks to get it, but it's worth it. The other thing is, yeah, remember that SSI claims have similarities and differences, which you need to know, which is what I briefly touched upon. And one is SSI, supplemental security income, is a welfare benefit. So you have to report to them constantly, income, assets, any money coming in, you know, frequently if people are in serious auto accidents or other accidents. And then they get SSI because they were really low on cash and didn't have enough, perhaps, quarters to cover for SSD. Suddenly, they're hit with a Medicaid lien and they have to lose their benefits because they get these large personal injury settlements. And by the way, in many long-term disability policies, if the condition that disables you is also the subject of a third-party action, like a personal injury case, if any of that is couched in the disability be compensating you for that disability that you filed a claim for and lost income, they will also try to recover that money from you. So it's very important for your disability lawyer to work with your personal injury lawyer in structuring how that settlement is arrived at. Okay, Gudrun, I think we're ready for the next question.
Yes, I just wanted to address an issue from a cognitive perspective. A lot of my clients are faced with these complex issues that you've just laid out and touched upon. And it's overwhelming to deal with all these little things that you have to be thinking about. So I just wanted to let the listener know that there may be a written format of this webinar so that they can refer back to some of the questions that we raised and answered. But also on a more immediate basis, I just want to let people know how they might address it when they feel overwhelmed by this large amount of information that needs to be taken care of in a time-sensitive fashion.
Right.
Many of our clients, patients, have trouble with multitasking, with reading, with doing things fast, with just doing 2 or 3 things at the same time that they were, before they became ill, was no problem, but now it is. Don't feel embarrassed, don't feel ashamed, don't feel guilty asking people for help, to go through the documents, to look for the documents, to talk to agencies that can help you to get information about yourself. Start organizing yourself in color-coded files so that you know what's where when you need it without making long lists that you're then going to lose and it gets frustrating. Just utilize the resources you have around you. It's for everybody's best. It's in everybody's best interest. There is nothing wrong with you other than that you're ill. So those were my words about how to approach this really large amount of information.
Important
And
point.
Barbara touched on many points that we will be going into more detail on as time goes on. So here's the next question then. When do I need to file for short-term disability, long-term disability benefits? And do I still need to work, or can I file when I'm not actively employed anymore? And Barbara touched on that already a little bit.
Yeah, this is like an atom bomb question, because if you don't file for these, most plans, and again, disclaimer from before, most plans require people to be actively at work. Now, being actively at work means, let's say you're sitting at your computer and day after day you're struggling. You know that it's everything, it takes everything out of you just to like open your computer and start keyboarding and reading emails. You know you're in trouble at that point. And if it happens for more than a week or so, you know you're struggling. When you begin to sense that, understand two things. One, you're not the only one who's looking at that. Your employer, and in this highly technical age we live in, you're being monitored for performance and productivity. So one of the things I said when we were preparing for this is I get calls from colleagues of mine who are on the other side saying, look, we want to get rid of this person. We can tell they're not productive anymore. It's been a nightmare. We don't know how to get rid of them. What's safe for us to do? And I say, sit down and talk to people and approach it so that, you know, they can work with you to protect themselves as well. And the truth of the matter is that when you have these sorts of problems, oftentimes we go into denial and we don't like to look at the reality of what's happening. In this context, ignoring the reality can mean losing an enormous source of income until you reach full retirement age. And again, not all policies say full retirement age. Some say to age 65, some limited for a lesser period. But the bottom line is that it's a lot of money to give up. And many of you watching this are younger individuals. You are people who perhaps you're not the biggest wage earners in the world, but if you're struggling like this now, and you're looking at age 25, 30, 35, 40, 45, 50, and even higher, if this goes till age 65, you have to think of the number of years you're giving up between 50 to 70% of your pre-disability income. And some of you also purchased supplemental income coverage through your employer, which can bring it up to 70 or 80% of your income. Do a little math when you're cognitively up to it, and you will be astounded with the sum of money you're talking about. So paying attention to yourself and your productivity, knowing what people are observing. Some of you have gotten poor performance evaluations. You know what's coming, and yet you're just hoping beyond hope that you feel better. It's a very dangerous game of Russian roulette that you're playing, because if you stay too long and they terminate you, your entitlement, except if you live in New York, your entitlement to these disability benefits flies out the window. It's a big, big risk to take. You're better off, at least, because once you file for short-term disability or long-term disability or both, you are protecting yourself so that in the event they terminate you, you at least have the right. You've staked your claim to these benefits and you're protected. I can't emphasize that enough, and I cannot tell you how disastrous it is, and how many cases like that we've dealt with. Oftentimes you have to report this, as I mentioned earlier. You have to just follow the instructions that are in the disability plan. It's, you know, it may be you have to report after 5 days, you have to file, after 7 days, you have to file for short-term disability to your direct report or whoever it says. I mean, literally, you just follow the instructions in the disability plan with who to report to. The other thing is, the short-term disability insurers can be a third-party claims administrator. In some cases, that's just an insurance company or some kind of outsourced vendor that the employer uses to look at everything and decide. The employer's like, we don't want to be bothered with this. We don't want to have to figure this out. And oftentimes they will bring in a third-party administrator when there is salary continuation attached to your plan, which means that if you've been there 5 years, and these are, again, just rough estimates, sometimes when you've been at work for a certain period of time, you will open up the disability plan and it will literally give you a menu. For employees working 2 to 5 years, you get your full salary for X number of months. And the maximum is usually 6 months, but it can be as high as a year. Sometimes in extraordinary circumstances higher, but the most common is 6 months. And they will tell you there. That's why getting that plan and familiarizing yourself with that, I can't emphasize that enough. So you want to know, because you want to be able to prepare. People call me all the time and say, I just need to prepare, Barbara. We have several cases in litigation now, and the people whose cases are in litigation are like, just give me an idea of how long I have to have a reserve in order to protect myself financially. And that's a reasonable question, and it's a fair question. And the same is true in these situations. When you realize you can't do it anymore, you need to know before you even start what playing field is so that you can protect yourself and plan financially. Yeah, and if you file for SSDI or SSI, you cannot be working at all unless you're working for a spouse, unless you're working for a family member, which we call that sheltered work. And we all know those situations. People keep their kids on who are otherwise disabled and unable to work. People will hire their best friend who fell on hard times because they can't work. That's sheltered work, but that's really rare and really unusual. In the world of Social Security, you cannot be working. And one of the things we discussed when we were planning for this webinar was how many people, I've had people come to me, I'm not kidding, after 10 years of being out of the workforce, and they'll say, well, you know, I want to file for disability. And I say, well, why'd you wait so long? Because Social Security requires you to prove your disability within 5 years of the date you last worked. The implications of that are pretty profound, because if you have not worked in 5 years or 10 years, we have to document that in the sometime within the 5 years after you last worked, we have medical documentation that you were totally disabled. Some people can't even leave the house. I have a client right now, he has been unable to leave his house in 15 years. And he was bereft because he couldn't produce any medical documentation. And that's why it's important to have a telehealth appointment. If you can't get somewhere in person, open up your laptop and schedule a telehealth appointment. Go to a clinic, go somewhere, even if you're low on funds, because you have to have medical documentation of your disability. And that's critically important. And in both contexts, but in the Social Security disability context, you are looking at another deadline that's crucially important to know. And again, there are lots of great Social Security disability lawyers throughout the country who can tell you. I'm happy to talk to anybody who wants to call. My initial consultations are free. And I know people say I'm crazy for offering that, but I'd rather drive myself nuts telling people what to do properly than you calling me after the fact, after you've blown the opportunity to correct yourself. And the thing that we discussed is you have to document with Social Security disability that you have been unable to perform substantial gainful activity, which is a legal term of art. It's not just common sense. It means that you cannot do anything for pay or profit when you try to do basic work-related activities, common work-related activities. And by the way, cognitive dysfunction is a significant indicator of your inability to perform substantial gainful activity. If you have a ERISA group plan offered by an employer, you have to comply, as I said, with the time deadlines. If you blow those time deadlines, you know, we've had cases over the years where people have come to me, they've hired like their personal injury lawyer to do these cases, and they know nothing about these kinds of cases in most instances. And they just blew the time period to appeal, because if the insurer denies the claim under ERISA, you have 180 days to appeal it. Well, people will come to me like a month after that 180 days, or even a day after that 180 days. And unless I can get the insurance company to agree to waive that requirement, we're stuck. It's considered by most courts to be a statute of limitations. So I cannot emphasize enough the importance of all of these deadlines, which is why, again, I'm not saying it's job business for myself. There are lots of good disability lawyers out there, but you really need to have somebody help you navigate this stuff. Under private disability policies, the same is true. You know, they'll often say you have to come up with proof of loss within 90 days of the disability. And why is that important? Because people often will say, I just was too sick. I couldn't do it. And unless we have a very good reason medically, pardon me, for doing that, for you not filing the proof of loss in time, they're within their rights to say no. Now, we usually fight those proof of loss arguments and win because oftentimes in our cases, our clients were just too sick or too cognitively impaired to do it. And most of these policies provide like little loopholes that you have to look for to get past those strict deadlines. Not so with the ERISA group policies, not so. Even with Social Security, if you miss an appeal deadline, there are several good cause exemptions to late filing, but not so with these ERISA group policies. The other thing is, inform yourself about the continuation of health information under the employer plan once you've been apprised of the plan benefits and requirements. As I said before, a lot of ancillary benefits, connected benefits come in when you qualify for long-term disability. Health insurance, life insurance, waiver of premium payments. There are many, 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 many good features once you qualify for long-term disability in a lot of policies, not all, but in a lot. And again, familiarity with that plan and policy is paramount. Yeah, we talked about the key points are the importance of active employment. If you are terminated or laid off before you can file for these benefits, you are not actively employed and your entitlement to these benefits ends. That's true in virtually every jurisdiction. As I said, some New York courts have found we should not punish people who are stoic enough to try to continue working while they're sick. I just want a case on that basis. But, even there, I mean, you have to just hope and pray that the judge is sympathetic to that argument. But in other jurisdictions, you're done. So it's not worth playing Russian roulette. And we talked about Social Security disability must no longer be engaged in substantial gainful activity. And Gudrun, I think we're ready for the next question, unless you have any comments.
Okay, I just wanted to again add something from the behavioral point of view. Again, this can seem overwhelming. It is overwhelming, and you really should not feel guilty, embarrassed, or anything like it to ask for help to prepare for the potential occurrence that you will go for long-term disability benefits, because it is so time sensitive that unless you have a person that helps you, you're well advised to contact a disability lawyer that can help you through this jungle of timelines and forms and formulas to not allow you to lose your benefits, like Barbara was saying. So here's the next question. Are all ERISA long-term disability plans the same, or are there different types of long-term disability plans under ERISA?
Well, as we've been hitting you over the head repeatedly, not all plans are exactly the same. There are certain generalities that you will see in these plans, much of which we've touched upon so far. I'm not going to hit you over the head with the actively at work and, getting the policies and plans so you know about continuation of health insurance, life insurance, and all those other things, which, as I said, when you're young, those things are kind of not so, you think they're not so important until you get sick and until it becomes a matter of getting treatment and having some kind of assurance that your life is not going to be thrown into a horrible tailspin. Many ERISA plans contain common provisions, but there are material differences between those plans, as we said. Yeah, and the other thing you should know in these plans, many of these plans contain offsets. Many of the ERISA plans contain offsets for Social Security disability. A common thing that I hear all the time when people call me is, oh, well, I had to hire the people that the insurance company told me to hire to represent me in my Social Security disability case. There is For MECFS and long COVID people, it is a nightmare to hire the vendors who do these cases for the insurance companies. And I'm not saying it's not every single one who does it, but lots of them, they're getting their business from the long-term disability insurance company. It is within their interest to make the business people who are farming them business happy. And what you will see I've talked about this in front of the National Association of Social Security Judges. And they were like, well, how can they, the insurance companies, hire people to work for them to do Social Security cases when there's a clear conflict of interest? And in my opinion, it's just my opinion, there is a clear conflict of interest, because many times what these long-term disability insurance companies want to do is they want to project long COVID MECFS cases as mental illness. They feel it's too expensive for them to accept MECFS and long COVID as actual physical illnesses, because physical illnesses under most of these policies go to the end of the policy duration. Whereas if they can use it as a mental illness, mental illnesses are only payable for 24 months under most of these plans. Now, there are some plans that don't punish people, whether they have a mental illness or a physical illness, but the majority of them limit payment of benefits in these cases to 24 months. And it's ridiculous. I mean, I cannot tell you, with every MECFS case I get tons of follow-up behavioral questionnaires from the insurance companies where there's no history of behavioral questionnaires. And in long COVID cases, what we discussed, when we were preparing for this, is something I was seeing commonly, which was that some of my clients who had long COVID were going to long COVID clinics, and because of knucklehead physicians who really weren't trained very well, and by the way, with some very august medical institutions, the physicians were writing paranoia, they were writing mental health issues, depression, where there was no history of it, because their own bias told them that that's what they felt it was. So one of the things Dr. Lang and I talk about all the time is the importance of looking at the medical records from those sorts of clinics, or even from your treatment providers. For years, there was an MECFS doctor who alleged that everybody who had MECFS had been physically assaulted sexually. I mean, it was crazy. So every single case that came before this doctor, there was always a notation about that. And it drove me nuts, because there was no proof of it, nor was there really any science behind that argument. So you got to be really, really careful to make sure that you are very selective in who represents you, because people don't think, well, it's a Social Security case, it's not my long-term disability. But guess what? The long-term disability insurer who hires those third-party vendors has you sign an authorization allowing them to see everything that this person is doing for you for this case. As a result of that, it is often the death knell of your long-term disability case if they win the case on a mental health basis. And in other cases, they totally torpedo the case completely and lose the case. And if that happens, you're really up the creek without a paddle too. Now, I'm not saying that if you win it based on an MECFS or a long COVID basis, that the insurer will accept it. Oftentimes they don't. They make the argument to judges. I've been in these arguments many times. It's apples and oranges. Well, yeah, because the long-term disability carrier often requires that you only document you cannot perform the duties of your own occupation, whereas Social Security requires that you can't perform any duties of any occupation in the national economy. So when Social Security finds you disabled, it's much more challenging to win a Social Security case because you have to prove there's nothing that you can do. Whereas in the long-term disability case, you just have to show that you can't perform the duties of your own occupation. So it's, in my opinion, crazy, but the courts often say, yeah, it's apples and oranges. Just because you won one doesn't mean you should win the other. So that's why you need, again, a disability lawyer who's experienced dealing with those crazy kinds of arguments. The other thing is, as I said repeatedly, and as Dr. Lang has said repeatedly, you want to make sure you know your plan. Now, there's something that just happened recently. Someone was trying to hire me, and they had only been at their job for 3 months. And they had been at a job that was connected, but not, they were working their job through an employment agency that farmed workers to a large pharmaceutical company. And unfortunately, within the first 3 months of their employment, they got really, really, really sick and couldn't work anymore. And they were hoping that because they had long-term disability coverage with the other job, that it would continue to this job. It doesn't. They're different employers. They don't cover. So that brings us to another issue you will see in these cases, which is pre-existing conditions. If you file a disability claim for a new employer within 12 months of your start date or the effective date of coverage, if you file a disability claim before that 12-month anniversary, they will deny it on the basis of pre-existing condition. The only exception to that is if there's something called continuity of coverage within your later employer. If your employer acquires another business and you worked for that other business, and depending on the nature of that acquisition, if that health insurance or long-term disability insurance continued with a continuity of coverage clause in the policy, you will be able to be covered for the long-term disability. But for the most part, you will be foreclosed from filing for long-term disability if you filed for benefits within 12 months of your start date. Again, some say even longer, some say 24 months. So you have to, again, from being familiar with the coverage itself is crucially important. So usually the way it works is they'll say, okay, you have to document disability if you file a claim for disability within that 12-month period. And 3 months prior to your effective date, you had treatment that you knew or should have known was related to the condition that disabled you, we will deny on that basis. Pre-existing condition clauses are challenging. We've won some of them, but it's very, very, very fact sensitive. So be aware of that too. So if you've got good, and I've had this happen, if you have great insurance, long-term disability coverage with one employer, but another employer is kind of waving, trying to lure you away, not knowing your health problems, and you can't handle staying in there for 12 months, you're going to lose your benefits. So it is really important to be very honest with yourself about your ability to continue working. The other common thing you will see in these cases, as I said, is disability is often defined in these cases as your inability to perform the material and substantial duties of your own occupation in ERISA cases. And it's also common in private disability claims, but that kind of policy language. And then either the own occupation definition will be the same throughout the duration of the policy to age 65, a full retirement age, or after 24 months of being disabled from your ability to perform the duties of your own occupation. After that, you then have to document that there are no duties in the national economy that you can perform. So we've seen so far, Social Security offsets are common. The pre-existing condition provisions are very common. The own occupation versus any occupation requirements for disability are very common. So those are some of the ones that stick out the most. And as I said earlier, you will often find, not always, but you will often find in these policies, the ability to offset what they have to pay from any third-party settlements that are related to that disability that you incur. The only place who can't do that, insurers can't do it, is New York. God bless New York. They have so many great provisions for people who are disabled. But what they say is, New York says by statute, no, insurance companies can't recover from, this person who's been seriously injured sufficiently for them to file for disability. They can't do that. We're not letting them do that from a personal injury settlement. What most jurisdictions say is it's allowable. So as I said before, you want your disability lawyer to converse with your personal injury lawyer, because in some instances, there's more than one way to skin a cat. Yeah, we've gone through all these other things under the key points. Know what the ERISA plan provisions are. Same is true with the personal disability income policies. Pay attention to deadlines, definitions. Be aware of all subrogation. Subrogation means that they get to take money back from you after they've shown that you've recovered either a personal injury settlement, Social Security. And by the way, under those Social Security subrogation, they cannot take the attorney fee that you've paid to the attorney. Attorneys in Social Security disability cases are entitled to 25% of whatever back benefits are owed to you, or $7,200, whichever is less. That is by federal law. Attorneys are limited to those fees. So when you pay back an overpayment, what the insurance company calls an overpayment, you pay back what Social Security gave you. Don't spend the money. Don't spend the retroactive benefits when Social Security deposits it, because under most of these plans, if you have an ERISA plan, you've got to pay it back to the ERISA long-term disability carrier, so that they don't declare an overpayment against you and start collection proceedings, and it gets crazy and ugly quickly. Under most disability income plans, you don't have to worry about that, because for some reason they don't. Most of the disability income policies that I deal with don't deduct for Social Security and don't have a lien against them. But always, again, look at the policy itself. Gudrun, I think we're ready for the next question.
Okay, and I'm just going to be piping in behaviorally again, repeating what I've been saying twice already and what Barbara keeps on also reiterating. Be honest with yourself. Take control over your life by following up on the paperwork, on a schedule. Set yourself a schedule. Knowledge is power. Sticking your head in the sand is no, no, no. Use your resources, set priorities for yourself, and very importantly, pace yourself. So you're not moving into post-exertional malaise that is on top of what you're already experiencing. So you have to really try and make yourself a schedule. How much do I read? How many phone calls can I do in a week? Do it every other day. Do it every other day for an hour, half an hour, 2 hours, whatever is appropriate. Just be mindful. Okay, next question. Since I'm not able to work on a consistent basis and have been absent a lot, my employer offered a severance agreement to me for my signature. That sounds good. It looks generous to me, and I could really use those funds now. Should I sign it, Barbara?
No, not without, look, the temptation when money is tight, and money gets tight very quickly when you get sick. Suddenly, things that you just thought nothing of, paying for month to month suddenly become extremely frightening when you realize that you're not going, first of all, part of your income is going to be slashed. So even if you get 70, 80%, there's also that 20% that is an issue. Under these ERISA plans, and I think it's important. I don't give tax advice to people, but under these ERISA plans, if your employer simply pays they pay for the premium before tax, that's taxable. It's an income substitute. So you got to remember that. That's going to be a taxable event for you. So it's not even that you're going to be getting the full, 50, 60, 70%. If the employer pays for that premium completely, it's a taxable event, it's income replacement. Secondly, if the employer pays, or if you pay through payroll, the employer simply, does the payroll work, but you're paying with after-tax dollars, it's not a taxable event for you. So you need to also look at the plan and see, is the employer paying for this premium or are you paying? I'm astounded that people never really look at their pay stubs, even the online documentation they get, they never look to see what's being deducted. They suddenly begin having to look for this stuff when they get on the phone with me and I'm like, okay, did you pay for it or the employer? I don't know. Then we look and we see who paid for it. And that becomes important because it's another slash of the benefit. But as respects severance agreements, and I have it all the time, people will say, I really need this money, Barbara. I have to sign this document. And what I say to them is, if you sign that document for a fraction of what your long-term disability insurance will pay, you will regret it, because maybe for the next few months, you'll have a couple of bucks in your pocket, but when it's gone, it's gone. And as I said, it may be taxable too, on top of everything else. So what you want to do is you want to consult with, because it's not just any attorney, because I get attorneys who negotiate these severance agreements and then call me after the fact and say, oh, I have a great case for you. And then I look at the severance agreement and they've waived their ERISA rights, but they're fooled because a lot of these severance agreements say that you are not waiving your right to ERISA vested pension benefits. So because these attorneys don't understand that long-term disability benefits are welfare benefits, are not vested, and are not pension, they are not waived under these documents. So if these attorneys were to go to court saying, Your Honor, we're filing suit, the other attorney is going to go into court and say, I file a motion to dismiss because look, Your Honor, they signed a document waiving their ERISA rights. And the other lawyer says, no, it said that vested ERISA pension benefits aren't covered. And the other lawyer will say, but these aren't vested ERISA pension benefits. So it's a sleight of hand. And it is very, very, very costly. So always when you get the offer to have a severance agreement, make sure you consult with an ERISA long-term disability insurance specialist about what we call carve-out language. It's very commonly negotiated. And from the beginning, but I'll deal with some insurance, with some employers, attorneys, pardon me, and they'll say, all right, just throw the language in. I deal with others who say, no, we're not going to give that up. Why? Because some of these corporations get discounted premium rates by allowing subrogation to happen, which means that if they refuse to let people waive their ERISA rights, their insurance premiums will stay low. But if they agree to it, they could get a spike in premium payments. So it's really important for someone who knows what they're doing to counsel you on whether or not you need to eliminate some language. You have a gentleman who he's very ill and he has a big family and he made a very good living, but they were offering him 1 year's salary. Well, that's very tempting, except he would be giving up millions of dollars in long-term disability benefits by accepting it. And I tried very hard to be reasonable with the employer's attorney, but she wouldn't budge. And the reason they didn't budge is I'm sure they had a subrogation agreement with the insurance company. So please be very mindful of the fact that you don't want to sacrifice benefits until you hit full retirement age for something that is worth not even a fraction of what those benefits are going to be worth. And by the way, some of these policies also have cost of living adjustments attached to them. They not only continue, some of them not only continue your health insurance at an employee rate and life insurance at an employee rate, because don't forget, once you file for these disability benefits and you try to get life insurance on the open market, you're essentially uninsurable. So giving up life insurance benefits, giving up health insurance benefits at a discounted rate, and giving up the long-term disability benefit, that's a huge cost that you're assuming here, okay? Yeah, we talked about those waivers, and I know it sounds really technical to say to you, oh, you know, this is one kind of ERISA benefits and the language only covers another, but suffice it to say that if you sign most of these severance agreements, you will be, without modifying them and without having a really experienced disability, ERISA disability lawyer look at it, because a lot of employment lawyers don't know the difference. They just don't. And they're really brilliant and really smart when it comes to employment law, but they are not employment lawyers. I mean, they are not ERISA lawyers. So you've really got to have an ERISA lawyer take a look at it. And if it costs you a few bucks to have them review it and change it, trust me, you will be very happy with that investment at the end. Yeah, as I say here, employee beware of employers bearing severance agreements, and the importance of carve-out languages. As again, I don't want to beat a dead horse, and I want to keep this so that you're not falling asleep during this presentation, but it's really important to keep these things in mind. Okay, key points. Do not throw the baby out with the bathwater, which is what we were just talking about. You don't want to abandon your right to between 50 and perhaps 80% of your income to get a short-term check. That's just silly. Do not sign a severance agreement until a disability lawyer looks at. In most cases, the severance you're offered by an employer are worth much less. Now, there are exceptions to every rule. I'm representing a client right now who has a terrible case against her employer, and that case is worth tens of millions of dollars. Her ERISA benefits are worth maybe $1 million. So in this situation, you know, if she has to settle that multi-million-dollar case and perhaps lose her disability benefits under the long-term disability policy, it would be worth it. But you have to do the math. I mean, you have to familiarize yourself. Yeah, and as I said before, while most of these plans, the ERISA plans, not private insurance, disability insurance plans, but most ERISA plans require you to file for SSD, you always want to get an independent lawyer familiar with disability, SS disability, to file the claim. My office does both. A lot of long-term disability insurance ERISA attorneys do both, some don't. But you should really try to have the person who's handling the ERISA disability claim handle the Social Security claim, one, so that everything goes in seamlessly, that the evidence all goes in. Social Security requires us to submit even adverse evidence. They don't care. So, and we do that. So my philosophy with my staff is very simple. If we can't win the case based on all of the medical evidence, then we have to just tell the client we can't take the case. I won't feign evidence. I won't lie about evidence. And I submit all the evidence because that's what the rules require. But you don't want the reverse to be true. You don't want a vendor for the insurance company limiting what they send to only mental illness, you know, psychiatric notes or psychiatric summaries. That's wrong. That's just absolutely wrong in my opinion, but that's often what's done. All right, Gudrun.
Barbara, so I'd like to ask you a question that just occurred to me. If I'm an ME/CFS patient, I now know that I need help. I'm calling your office for the free evaluation, but I do have cognitive problems paying attention for an hour or so of very complicated information. is it allowed to bring another person to that conversation? B, is it allowed to tape that conversation?
Yeah, I mean, I have no problem. People often tape my consultations, and they'll say to me, is it okay? And I say, look, whatever I say to you, I'm saying to you regardless of whether it's taped or not. So honestly, I think I prefer it to be taped. The other thing people will say to me is, do you mind just, once we talk about it a little bit, can you answer some of these questions in email format? Because I just can't remember. I don't have a problem with that either. Obviously, I don't do it continuously because I have to make a living too. But if they have some questions that they can revisit and look at the answers, I don't have a problem with that. The problem I have with bringing another person into it, and I tell clients this, or potential clients this all the time, is when you have a third party present in either an email or in a consultation setting, you have then waived attorney-client privilege. So that if the case goes to litigation, and if during the course of litigation, it is revealed that this other person was present, they can depose that person and ask them everything you said to the client, everything the client said back to you, because you gave permission for them to be present. It is, and I understand that, and oftentimes we really don't have a choice because people are so cognitively impaired. Honestly, deposing them would be, and I've had it happen where people are so cognitively, and the other lawyers are looking at me like, what is this? And I say, that's what we've been trying to tell you. But that's the least favorite approach I take. The least favorite approach I take is bringing a third party into it because of that reason.
Right. That was a great answer, a very important point, I think. From a cognitive perspective, taping is better than taking notes.
Yeah.
A lot of the patients that I have are desperately trying to take notes, and it just doesn't work.
Right.
The notes are illegible. They don't make sense. It is just
Or
not.
they're just plain wrong. I mean, I
It's
have
not a good
people who
idea at
leave
all.
a not out of the sentence when you say the one thing you cannot do is this, and they'll be scribbling and say the one thing you can do is this, which is an awful situation. I have to take a break for a second. I'm sorry.
Right. So if you have taped the conversation with your with the attorney that you talk to, just pause it when you start to feel overwhelmed. Don't try and power through it, because it's just going to be adverse to your health. Just know that it's there. You can do it the next day or the next day. It's not going anywhere, but you're already miles ahead of people that have not started this information acquisition. So that's my 5 cents to this.
Well, one of the things I'd like to add to that, Gudrun, is that one of the things I say to people is we do a very extensive interview. Our interviews can last 1 to 3 hours, which is a lot for people with ME/CFS or long COVID. It's a lot. And what we do is, and we can always tell, we're all doing this for a very long time, my attorneys and I, so we can all sense when somebody's petering out and it's exhausting. And we know that the next day they're likely not going to be in any shape to continue. So we will offer to break down the interview in several steps so that they can.
Very good.
Yeah, I mean, some people say, no, I just want to get it over with. But
Right.
if they're really out of it, I sometimes insist, let's revisit this in a couple of days,
Yeah, I think most of patients with either long COVID or ME/CFS or a combined picture know that I want to get it over with mindset is not working.
It doesn't.
Because that is the one driver that definitely puts you into post-exertional malaise.
Well, and not only that, but when they begin to crash, they're not remembering it. They're not remembering.
No, because it doesn't go in.
Right.
Yeah.
So it's important to be, again, it's really tough to like say to people, look, you have to be realistic about how sick you are and how limited you are. And particularly for people who worked all their lives, nobody wants to have that conversation. Nobody. So, but you have to really, as a judge who hears these cases all the time, said to one of my clients, she had CFS herself. And as she said to one of my clients many years ago, if you're going to complain anywhere, this is the place to complain. So you want to be able to remember, and it helps sometimes. And people will say, they'll ask my paralegals, what should I have ready? And they'll give them a checklist of things, their doctor's names and addresses, phone numbers, dates of visits, things like that. But the important thing is, if there are things you really want to discuss with the lawyer during the course of this, jot it down when you're having a good day. You want to make sure that if there's anything important, and my recommendation is that that's the time that you get involved with a family member or close friend and say, what do you think I should tell them? What do you think? What do you notice about my problems? And it's really a tough thing to be honest about. But that's, oftentimes spouses, children, and friends are good friends, are very honest, and will give you that kind of input. So that's my recommendation.
That is so true. And I always say to my patients, this is the time where you are finding out who is a friend and who is an acquaintance.
Yeah.
The acquaintance sort of peter out over time,
Right.
because it's a lot of work to be a friend to a person that has a chronic illness.
Yeah.
And the friends, maybe if you have 3 or 4, that's a lot. Be happy with that.
Right.
All right.
As we know,
Next.
canceling appointments is a big thing that happens when you have ME/CFS or long COVID. The day that you anticipated was going to be a good day, not so much. And a lot of people just don't have the patience for it. But again, that's why you want to keep your circle tight with people who really do care.
That's exactly the point. Here's the next question. You ready?
Yep.
Do I really need an attorney, Barbara? Really, an attorney to assist in applying for SSDI, SSI, and or short-term and or long-term disability versus just trying it on my own? I mean, I have an advanced degree. What are the pros and cons?
Right. As far as the advanced degrees go, and I often find that a lot of people with ME/CFS and long COVID are like, truly, we're always used to being the smartest people in the room, because seriously, many of them are professionals. Some of them aren't, but many of them were. And, I have a client now who, I can't share what her title was, but it was amazing for someone in her early 40s. She was literally a captain of industry. We were fortunate enough that she was able to track down her when she was coming into this top 5 financial institution in the country. When she was coming into their employees at an entry level, they had neurocognitive testing done. And she tracked down the neuropsychologist, and the neuropsychologist showed that she had a full scale IQ of like 150. And when she had the recent test results, she was 75. So what happens is sometimes these illnesses can take a real chunk out of your intellectual functioning. And so just as an aside to the point you made, now many people aren't affected that way, but some are. So yes, you do need an attorney to do the SSDI, SSI, and long-term disability cases and short-term disability cases. I'd say SSD and SSI, I would tell people, you know what? you can try to do it on your own. They'll take applications online. You got to go to www.ssa.gov and you can file the application. And if you have a family member there who's more proficient, perhaps, than you are cognitively at this point, that's worth doing. It is okay to do it in SS cases, because SS cases, there's a lot more flexibility in what you can do. You can try to reopen if you screw it up too badly, or if you don't file an appeal on a timely basis. An experienced SS lawyer can reopen that application. Usually it takes a little effort, but it can be done. There are no terminal consequences to you screwing up that initial complication. And what I tell people when they first call me is, look, you can give it a shot. If you want to try to file that SS application on your own, we have lawyers who that's all they do. But if you want to try to do it on your own, do it. And if you get denied, then we'll call us and we'll represent you. I do not have that same cavalier attitude with people on the ERISA long-term disability insurance side, or even on the private disability side, because errors in those contexts are terminal, or they can be. And it is not worth risking a percentage of your income till full retirement age or till age 65. It's not worth it to not hire a lawyer in those circumstances. And by the way, if your income is really low and you file for these benefits, I will often say to people, it's not worth it for you to pay me to pursue these benefits. Because after the insurance company gets done offsetting what the Social Security benefit will be, you'll wind up with nothing except a big bill from me. And it's crazy. So that's the other reason. And, reputable disability lawyers will be honest with you about things like that. They're not going to take your money for a case where you're going to lose money in the end. So that's the other reason why it's important to do that. But Social Security, you have more flexibility. ERISA, short and long-term disability, you do not. Yeah, and that's, one of the key points we raise is, you have to really weigh the pros and cons honestly, I have people say, I don't care, it's the principle of the thing. Well, you don't care because it's the principle of the thing. But if you wind up owing me a ton of money on a case where you walk away with virtually nothing, no, it's not worth the principle. The only one that's getting rich off that is the attorney. So be wise in your choices on these things. It's important. Gudrun, I think we're ready for the next one.
Yes, I just wanted to address a point that you made about being cognitively competent to make decisions and to just deal with this whole thing by yourself.
Right.
And in my experience for like almost 30 years, the biggest, scariest fear of patients generally is, am I dementing?
Yeah.
Or is this something that might be going away at some point?
Right.
And so in my experience, and I think also in the scientific peer-reviewed literature, we can say that most cases, the majority of ME/CFS, as well as long COVID cases at this point, are not neurodegenerative disorders in that you become like you get a dementia.
Right.
In most cases, the problems the person has are in attention, processing speed, and working memory.
Mm-hmm.
That's the trifecta of ME/CFS long COVID.
Right.
And that trifecta can be present to differing degrees. So some people have more of an attention component, some people have more of a processing speed component, some people don't even have a working memory component. Right. But usually it's affected by the slow processing speed. And so you have this cognitive, I call it cognitive syndrome. And when you have that cognitive syndrome, in this dynamic part of overall intellectual ability that is driven by attention and speed,
Right.
it's affecting your ability to synthesize and compile information and get several points of view at the same time and come up with one decision or one answer. That is the part that's affected. The part that's not affected is your ability to comprehend things, to make decisions, only you're much slower at it.
Right.
And in our world, people are just not talking slowly or talking in pieces or are in any way sensitive to you not being able to follow along as quickly as they present the information.
Right.
So that does not mean you are a dementing person. You just have that part of the intellectual ability that is not functioning properly.
Right.
So I just wanted to throw that in because that's one fear that people have, that they're going to be, similar to a person with neurodegenerative disorder.
Because well, there are days, I don't think there's in modern world, I don't think there are many jobs that don't require people to keep up quickly and multitask. And if you can't do those things, you're made to feel like an outlier, and you're an outcast, and you're like, oh my God, am I losing my mind? And that's a great point, because people are afraid to undergo testing. They're afraid.
That's right.
Subject themselves to, particularly younger people, they're like, why do I have to go through that? Well, the reason you have to go through the testing is it's about the only way we have, as you know, to show what the brain is functioning, what level the brain is functioning at in all these different domains, processing speed, working memory, things of that nature. And if commonly those are the things we see in ME/CFS cases, which you and I both know is what we see. When I go to court on a case, if the judge is looking at me like I'm talking in a different language, and I say, well, Your Honor, let me just make it plain, and we will go through what your report says. This person presents with classic ME/CFS and long COVID cognitive symptoms. It doesn't mean they have to have dementia. It means that in the context of the job that they were hired to do for their own occupation, or most jobs in the national economy, they just can't keep up. And on days where they're experiencing post-exertional malaise, they physically and cognitively can't do it. And the example I always give is, if you imagine the worst flu you've ever had and being put to a test. You're being tested by the judiciary that day to see if you're competent. Do you really want to undergo that testing on that day? No, you're going to postpone it. These people can't postpone it for the rest of their lives. And one quick anecdote, and I hate doing it, but I think it's very telling. Many years ago, I represented someone who was the head of institutional planning for a very large financial house internationally. And he had ME/CFS, and he could ski on his good days. He could go out on a yacht on his good days. He could fly. He could do all these things. But he would freeze. A man who had to decide what investments should be made for institutions, including the federal judiciary, what decisions had to be made to ensure the pensions were secure, the reserves were sufficient. And when he came to see me, he said, I look at all that now, and it's like, I want to cry. I don't even know what I'm looking at. And this was somebody who had profound responsibilities for decades. And so when we went in front of the judge, of course, the insurance company comes in with the tape showing him skiing and going out on boats. And he said, Miss Comerford, he's living the life I want to have. And I said, Your Honor, okay, One of the institutions he has to make investment decisions about is the federal judiciary. You've seen his neurocognitive testing. Do you want him deciding whether or not your pension's going to be solvent when you retire? He said, all right, that's it. And he found in our favor. But the point that I'm making is the point that you're making. You don't have to be someone who people wheel in and out of a room. You can be someone whose mind is just not functioning sufficiently for them to do their job.
And that is so true, Barbara. And then we're moving on. It's great if you are, you know, a high-powered person professionally, but if you're just a person that is trying to cook a nice meal for your family, you have your iPad or cookbook right there at the stove, and you're starting up, getting all the ingredients ready. You put it in the pot. Wait a minute. Was it supposed to be sugar, salt, or pepper? I got to read this up again. So you go back to your iPad or your cookbook 10 million times, exaggeration, but a lot more than you used to just cook what is most likely used to be a simple thing for you. Cooking is a multitasking event. So if you've never had problems making a meal that has maybe 10 steps and it came out okay and it tasted good, but now you can't even get the onions and the potatoes in the same pot at the same time without burning one of them, you have a problem. It definitely if you have ME/CFS. So, you know, it's happening at the house, at the stove. So when that happens to you repeatedly, you might want to consider and think about, where am I going to go next?
Well, and it's if you're doing that in a work setting and you're reporting to other people and they start noticing the quality of your work before you got sick and now, they're
Onions are burned.
Bookkeepers can wreak havoc. Somebody who's answering the phone, who's not getting phone numbers properly. I mean, I'm not joking. There are minor things that people realize they're losing a step on. They don't want to see it, but guess what? Their employer is seeing it and they're noticing it.
That's right. Healthcare providers give out the wrong medications, give out the wrong prescriptions, give out no prescriptions, give no medications. We've had it all. We've seen it all. All right, moving on. So now I decided to go for a lawyer, Barbara, but do I need to be concerned about whether an attorney is licensed in the state I live in?
Well, let's put it this way. With Social Security disability cases, Social Security is based on a federal statute. Attorneys, as long as they're licensed before the Social Security Administration, they can do hearings all throughout the United States. We do them all the time. Once the case gets to a lawsuit, right? If you're going to sue Social Security for not reversing an adverse decision, what we generally do, most attorneys do, is hook up with local counsel. And we'll work on the case or make a pro hoc vici application. That means you're going into the court and showing the court your credentials and what you've done and letting the court decide whether you're sufficiently knowledgeable to appear and make an argument. Most Social Security cases, quite frankly, years ago when I first started doing these cases, you had to make in-court appearances. Most Social Security cases in federal court now are decided on the papers. So, you know, an attorney who you may hire who's in state because they're licensed in that state, that attorney can say, okay, you roll the papers and we'll work with you and sign off on it. And that's commonly what happens. The same is true with ERISA long-term disability cases. If my associate, ERISA is a federal jurisdiction, obviously, but if we're going to be litigating the case in federal court, we can make, again, the pro hoc vici application, which is a motion to get the court to acknowledge that we deserve to appear in this case because we're sufficiently credentialed. or we have attorneys in my office, we have attorneys that are licensed in several states. So we will do it that way. With respect to disability income policies, those are the ones you purchase pardon me, yourself or through a broker. In those cases, you have to be licensed in the state. So if, however, the long-term disability insurance company is headquartered in your state, in our case, like Prudential, we can, even though my client may live in Oshkosh, Wisconsin, if they hire me because Prudential is headquartered there, I can take the case. And again, with all the other states that my lawyers are licensed in. If no one is licensed there, the insurance carrier isn't licensed there, then it's a different story. We will probably have to work together with counsel in that state and basically serve as background for them. There's been a recent US Supreme Court decision that may allow us to do that. There's this notion of what they call minimum contacts in states, which is why we have to do what I just described. But the Supreme Court seemed to be opening the door a little bit to allow that notion to be not quite as strictly enforced. So that would be very good news. And I think we covered the key points part of this. I think we covered quite a bit of what we just discussed. We talked about Pro Hoc Vici applications. We talked about ERISA litigation cases. Okay. I think the other thing I would like to lightly touch upon, which I, for some reason, got to in this key point section, is the standard of review in ERISA long-term disability insurance cases. Now, I know this isn't a webinar for lawyers, and that's what I'm used to teaching, but there is something you should know, because people just assume when they come to me, they're like, but I have all this proof that I'm disabled. How can they not pay me? If we have to sue, don't you think this information is enough to convince a court that I'm disabled? Well, if a court could do that, yeah. But ERISA has what's called an abuse of discretion standard, and it's arbitrary and capricious standard. So what does that mean? That means that if the employer in drafting their plan says, we have discretion to decide this case however we deem fit. If language to that effect is in there, and believe me, courts have construed it to be in there even when it's not that clear, if it's in the plan, that means that they just have to have a reason to deny the case. So commonly what you'll see in these cases is they'll hire a nurse, and I'm not putting nurses down. Trust me, my mom was a nurse. I'm not putting nurses down. But you could have a neurosurgeon, you can have 5 medical academics, you can have people with sterling credentials who actually treated the person, give you song and verse, the chapter and verse of why this person is medically disabled. And they can bring in a nurse, and the nurse can look at it and say, nah, I don't agree with this. I don't think any of those things disable this person. There are cases with courts that are aggressively opposed to these cases where the courts have said, yeah, okay, well, they had a reason to deny it. So that's why people unrepresented usually can never win these cases. And by the way, it has to be done before you have to present your arguments before the administrative record is closed. Because under ERISA and under the cases decided under ERISA, anything that happens after the record is closed, the court can't even consider. And anything that happens before that has to be documented and fleshed out in an appeal. So if you're saying, and I get this all the time, people who let the entire administrative record close and then had brought me and they did, honestly, if it were a disability income case, it might be persuasive. but they never argued why under ERISA there were violations of ERISA that happened in this review. So only experienced ERISA LTD lawyers can do that, because we know what all the minefields are. We know things like cherry picking the record. We know the citations. We know the Code of Federal Regulation provisions that don't allow it. We know about full and fair review of the claim and what the cases discussing full and fair review entail. And we can write, our appeals are often like 50, 60 pages because we go through every page in the administrative record. And another thing, the minute the insurance company, the ERISA long-term disability insurance company, denies the claim, the claimant is entitled to look at the entire administrative record and what the carrier looked at and considered before they denied the claim. That is where where we get our ammunition to appeal the claim. If we've done our job, even if they turn us down in the end, we have handed the judge a package, because all a judge can look at is what happened before the administrative record is closed. You're not going to get, for the most part, you're not going to get depositions. You're not going to get interrogatories. In ERISA long-term disability insurance cases, the administrative record is essentially the end game. There are a couple of exceptions to that, which attorneys are familiar with, but I don't know if I want to bore you with that. But suffice it to say, if they abandon the case, you file a claim, they send you back a letter not explaining anything, because they're supposed to explain what happened, why they denied the case in detail, and they never do. They're supposed to tell you when the statute of limitation runs, they never do. But if they just say, no, we disagree, our nurse reviewer looked at it and we don't find you disabled, you appeal it and then they just ignore you, you are entitled to get what we call de novo review at that point in front of a federal judge. And what that de novo review basically says is then the judge can consider things like discovery, depositions, interrogatories, but they have to do it by motion anyway. But they will also be able to decide the issue of disability. Whereas before, under an ERISA arbitrary and capricious review, all they can decide is whether or not the conduct of the insurance carrier was arbitrary and capricious, whether they abused their discretion. That's all they can decide. Once you get a de novo review, then they can decide the issue of disability. I know that sounds like lofty legal principles, but trust me, the lack of knowledge on the part of the claimant trying to navigate all this is really, really a nightmare for claimants. So I beg and plead with my people who call me after they've, let the administrative appeal period pass and the administrative record is closed. I try to give them some counsel if they want to file the case on their own, but I can't do it because they haven't done what needed to be done to win the case. And that's kind of important. And in disability income policy situations, they will allow discovery. They will allow, because you bought the coverage, you're the boss, you're fighting with the insurance company. Once you file suit, I've had cases where we did depositions and other discovery right up until the time we tried the case. In some cases, years ago, I used to do discovery right in the middle of trial. So it's much more flexible and it's easier. But again, you really need disability counsel to help you along with this.
Well, now that we've figured out how important it is to be informed, to get your ducks in a row, to ensure that your financial future is not imperiled. We completed the first part of our webinar, and we'll go on to the second part, because now we'll talk about what to do when the person decides to go on disability. We are now meeting to go to the second part of our webinar. We decided to go on disability. What to do now? Barbara, gonna ask you the question that is burning in many people's minds. How do I find a lawyer with a high probability of success? Do they need to have past experience with preparing ME/CFS and/or long COVID disability cases for SSDI, as well as employer private insurers, and why?
I think the answer to those questions is yes. I think that you want someone who believes in ME/CFS and long COVID, and believe it or not, that is not so easy. I mean, years and years ago, as you both know, I had ME/CFS, and I did a lot of work, not only for plaintiffs, but for insurance companies. And when I got back on my feet, and I was able to do it because I had the most wonderful partner, law partner on the planet, and he was like, you are the business, so however much longer you take. So I've been where you all are. I've had to, on good days, do what I could, on bad days, just crash. But I was very fortunate because ultimately I could get back on my feet again and, have a very successful practice. I think that in those years, what I learned is the condescending and awful comments that people unknowingly made, which was, oh man, you're not one of those, they're like hysterics, those people, they're crazy. I duked it out with the medical director for Prudential at a seminar. Not physically, but intellectually, because she was just arguing that CFS was based on junk science, and I had to educate her a little bit, quote Tony Komarov. But the bottom line was that it's amazing to me. It's doctors who don't know. It's, I was cross-examining a doctor one time, and a Dr. Richard Podell, who I owe enormous gratitude to, who was a devoted, wonderful, loving doctor. He and I and a bunch of other lawyers, bunch of other doctors sat on an CFS advisory committee, and the state of New Jersey gave us funds to publish a physician's manual on how to recognize and diagnose CFS. And I was presenting, not my section, because I wrote a chapter on proving disability, but I presented, and while I was cross-examining him, sections from Dr. Podell's section and some other doctors, and he said, oh, Jesus, that book isn't worth the paper it's written on, without any scientific basis to challenge it. And that, unfortunately, has improved somewhat, but has not improved enough that it should, because you'll still get doctors to this day snickering and saying things about ME/CFS and long COVID. And as I said earlier, long COVID clinic physicians are often, you really need to vet them carefully to make sure that they actually believe in the illness. So I think it is crucially important that you find a doctor who is knowledgeable about ME/CFS and long COVID,
And an attorney too.
a lawyer who is knowledgeable and believes in ME/CFS and long COVID, and you can grill them about it and ask them what their past experience has been with these cases. I think that's perfectly okay. Initially, when I got back to work, I started talking to people in different CFS advocacy groups, and I wound up sitting on several CFS boards. But the bottom line was that a lot of my business was coming through those advocacy groups. So what I tell people is, look, in your area, reach out to advocacy groups who do ME/CFS work, long COVID work, and ask them for recommendations, and even if it's somebody I get calls from everywhere on all different kinds of disability claims. I talk to people about their claims because I know how scared they are. And what I hear all the time is, there's nobody in my area that I can talk to. There's nobody who wants to touch this case. They just don't believe in this. So, but I'll direct them to advocacy groups and people they know. And, technically nobody can endorse a lawyer, no reputable place, like OMF and other places. They can't put, these are the doctors and lawyers we recommend. But what they can do is gently give you some material and nudge you. I tell people, look at the website. You want to make sure that this person understands ERISA disability, Social Security disability, ME/CFS, and long COVID. You want to talk to people who have used that attorney or have used another attorney who they really have faith in. You want to reach out to attorneys because attorneys will know. A lot of attorneys say, oh yeah, I give all that to this person. So doing a little investigation on your own is a good way to do it. You want to see if people have published articles on this. You want to see if you go on Pacer or other things, whether or not this person has litigated any ME/CFS cases. You want to do that sort of thing and what the result was. That's my recommendation. As I said earlier, I offer initial consultations for free with both SSD, SSI, and ERISA and private disability insurance cases. Again, that doesn't mean that you call the place 40 times and say, but you said you get an initial consultation for free. It's not an endless situation. So make sure you clearly understand what the parameters are of that initial consultation. And you want to check out the attorneys to make sure that they're good and reputable lawyers. And by the way, it's no reputable lawyer is going to get upset with you for asking questions. They're not going to bark at you unless they are totally ego-driven and insecure. They're not going to bark at you for asking questions about their credentials. They're just not. And you want to make sure that the attorney's experience is something you're comfortable with. When my former associate and I were arguing a case in front of a federal judge, there were two people in the audience who approached us on break and they were being represented by other attorneys, but they wanted to hire my firm. And I said, no, those attorneys are good attorneys. I knew they were attorneys. No, but you just won this big case. I said, yeah, but you've already got a good attorney. You don't need to switch to another attorney. So sometimes it's important just to do your due diligence and make sure. A lot of times people will call me and complain about their attorneys, and I'll be very honest with them and say, tell me their name. It's not a big bar. We don't have like zillions of people. It's not like personal injury practice. So those of us who've been doing it a while know who the people are, and whether you could ask them questions. I have people call me about this one particular attorney. She's brilliant, but she's got a horrible attitude. And they'll say, no, I couldn't stand her. I couldn't talk to her. She was so mean. And my response is always, okay, are you there for her personality or are you there for her legal knowledge? Now, they'll say, I don't care. I have to have both. And I understand that too. So you want to make sure that you fit with this person's personality, their legal expertise, and their knowledge of your claim. I think that's it for that, Gudrun.
Okay, so in general, what you're saying then, Barbara, is approach this issue professionally.
Yeah. Yep.
And you're the client, you're the customer, so to speak. You have to be comfortable, and you need to expect to be treated with professional courtesy.
And it's a very intimate relationship. You are opening up to this attorney about every physical, cognitive, and sometimes emotional weakness you have. So if it's somebody who's going to just, cast you aside and ridicule you, not directly, but make snide remarks, that's not going to be a comfortable fit. It's like getting a great pair of these gorgeous shoes and you put them on and 2 seconds later they're killing your feet. It doesn't make any difference how beautiful they look if they're not comfortable,
Exactly. So we've talked about this in the first segment already. What type of information and materials do I need to collect to successfully support my case? Isn't it enough if my doctor just says you're sick and you can't work?
Yeah, well, no, unfortunately, that's not the case, because physicians have to, what we have in the law is something called a net opinion. And what a net, and New Jersey hates net opinions, and we have lots of case law on it. What it says is to say this person is disabled, to reach a conclusion without flushing out the facts and the medical reasons why, is not considered a valid report. And frankly, while most jurisdictions don't talk about net opinions, they actually, their opinions reflect the fact that they won't accept net opinions. You know, nobody wants to have, no judge wants to hear a doctor say, well, I just think they're disabled. Well, why? Well, look, I'm genius, I'm brilliant, you know, I just think they're disabled. No, it's not gonna work. So you have to have, if a physician says, you need to have these tests done, we have to run these blood panels, we have to do neuropsych testing to document your cognitive dysfunction, we have to have a cardiopulmonary exercise test done to see whether or not you experience post-exertional malaise. How is your heart and respiratory system responding to your minor effort to do things? If your doctor tells you that that's necessary and you don't do it, it will hurt your case. And many of these tests are expensive. But as I tell people, if you were buying a house, you would take the time to put money aside for a down payment. And the same is true with your disability case. You have to, if you have to borrow from family or do things like that, if it means your case will either be approved or not approved, it's really important to invest in these diagnostics. They're very important, particularly because there is such, you know, disdain in some circles for ME/CFS and long COVID. You want to have as much medical documentation as you possibly can. And neuropsych testing is like a gold standard diagnostic for cognitive deficiency. You know, I've done CLE, continuing legal education seminars with neurologists who get questions on traumatic brain injury and other things. And they'll say, well, you know, isn't an MRI showing a subdural hematoma enough? Isn't it? And they always say, no, if you want to see what the brain is doing in response to that injury, you have to see a neuropsychologist. That is the person who tests how your brain is functioning. All we can do is show you a picture of whether or not the brain is responding in a certain way. And in things like post-concussive syndrome, traumatic brain injury, ME/CFS cognition failures, you're not going to see, usually, you're not going to see any adverse MRIs or CAT scans, maybe a PET scan or a SPECT scan, but you're not going to see it in those other diagnostics, which confuses people completely. So, you know, I don't mind educating judges. I don't mind educating my adversaries, but I do have to have the ammunition to do that. And to do that, I need things like neuropsych testing, CPET testing, and things of that, and, you know, blood panels, you know. We want to talk about medical records. So medical records are crucial, and medical diagnostics are crucial. To support a Social Security disability case, you have to have medical signs and symptoms documented by objective medical evidence. In ME/CFS and long COVID cases, you're, as I said, gold standard CPET testing by doctors or physiatrists who are accustomed and who are knowledgeable in testing people on this. And the same is true with neuropsychologists. I mean, Dr. Lang is the best in the country, in my opinion. She, and really Dr. Wilfred Van Gorp, there are a few names that I really have tremendous respect for them because they are very, very, very familiar with ME/CFS neurocognitive deficits. And if you get a neuropsychologist who is not familiar with the common signs and symptoms and the common domains that need to be tested, it's going to be disastrous. It's like throwing money out the window. So my advice is get a neuropsychologist who is familiar with it, get a CPET tester who is familiar with ME/CFS along COVID. You want to start collecting documents early. One of the things I tell people is, now with electronic record keeping, it's pretty easy to download your electronic records from MyChart and any of these other electronic record processing that hospitals and physicians now must be in compliance with, particularly hospitalists, people who work for hospitals who, you just need your sign in and your password. And in our situation, my paralegals, the attorneys will say, we need these records. Historically, what we used to have to do, order the medical records through a third-party vendor, wait forever to get those records, fight with them forever to remember to send us those records. And then if we were lucky before, we had to go to court, get those records. Now, we just ask the client, because a lot of them are cognitively impaired, will say, okay, what's your sign and what's your password? They'll give it to us, we'll download the records, and then they can just change their password. So we don't have to have those kinds of delays. Now, unfortunately, some of my attorneys tell me particularly with their SSD cases, they don't always get every document that the client has told them or every test result that the client has told them they underwent. So you have to be careful to make sure that the electronic record includes everything that you went through. And if it doesn't, you have to contact your physician and request it, or the attorney can request those additional records the way we manually have to do it. But for the most part, what you will get in the electronic record is very reliable. The other thing that is, I've been saying this for decades, write a journal. Keep a daily journal, even if it's just woke up today, very bad day, can't even think straight. I'm just exhausted all day. You want to keep a journal talking about your signs and symptoms, because one of the things that I've discussed with Dr. Podell, Dr. Lang, and a number of other physicians I've worked with over the years, they're like, my patients don't tell me how much they can lift. They don't tell me how long they can sit. How am I supposed to answer these questions? You're going to give them the answers if you keep a journal. If you keep a journal, couldn't sit more than 5 minutes, how to lay down. Because a lot of ME/CFS people will say, I can't even sit up very long because I get, if they have postural orthostatic tachycardia, if they have, neurally mediated hypotension. These are all things that affect the nervous system, so that sitting can exhaust people because they're vertical. Part of their body is vertical, and their blood is like, not cooperating. It's not going to the brain. So what they'll say is, I get exhausted just sitting, Barbara. I can't sit for more than 5. I got to lay down. I had a client who was deposed while she was laying in her bed. I had this federal court case we had in Massachusetts in the last year that Dr. Lang was an expert witness on. The client was giving testimony in the case, laying down in her bed because she could not sit or stand long enough to do it. But all of that stuff, and she was documented to have POTS. She was documented to have all those kind of orthostatic issues where she just couldn't remain vertical. So you have to keep, the medical records are very important, but your doctor's not going to be able to answer these questions or fill out these forms unless you are journaling and can literally describe that phenomenon. The client that I had that we were in federal court in Massachusetts was saying, I just didn't think to tell my doctor this. It sounded so stupid that I couldn't even sit up. But it was crucially important for her case. She was a psychologist. She was somebody pre-COVID who couldn't function. And so it's really, 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 really important to keep a daily journal. And when you go visit your doctor, you say to the doctor, look, I don't know if you can use this or not, but here's my journal for this month. I'm going to ask it to be made part of the record so that you have this. Now, the doctor may, what the heck is this now? But you know what? They will really appreciate it when they get that form in the mail and they have to answer all these questions because they can just write, see attached. citation notes attached. And they won't be calling attorneys or calling a client or pulling their hair out. You will have given them what they need, and it's directly from you. The other thing is, yeah, we talked about getting evaluated by reputable practitioners, people who are either board certified or who have a lot of experience in this field and who've been doing it sufficiently long that they can understand. I mean, there are a lot, in my MS cases, and I have quite a few of those, I'd say at least 50% of the treating neurologists will say to my office, oh no, we don't fill out forms like that. We just don't get involved in the disability process. And one of the things that I have to try to explain to them is this impacts your patient's health. I know your job is not to fill out more forms for insurance companies. But if you don't fill out this form, you are profoundly negatively impacting your client's ability to function. And by the way, perhaps their ability to maintain their health insurance with their employer if their long-term disability gets terminated. That changes some minds, but it's a fight. So we've talked about all the key points we've talked about. I think, Gudrun, you're probably better to talk about the neuroradiological workups
Yes.
But the two things that I will cover before you cover that are the medical records talking about your illness, including your journal within the medical chart, and gathering statements from people you're close to, your spouse, your kids, your close friends. I mean, I cannot tell you how persuasive insurance companies and judges find that information to be. I will talk to a client for a long period of time and they're like, no, I'm fine. I can do things. And then their spouse will be like, are you kidding me? You can't even take the garbage out. You can't. And that's when you learn how significant it is. I mean, many, many moons ago, I had a case where the guy had psoriatic arthritis and he kept telling me he was fine. And then his wife made him roll up his sleeves and his entire body, which was covered by his suit and shirt and pants, was nothing but open wounds, and his bones were breaking under the weight of all of that. And he literally could barely walk, but he was so proud that he was not telling me. And those kinds of facts are crucial. You can't be proud in this situation. So anyway, Gudrun, I'm sorry, you were going to talk about the neuroradiological results.
Yeah, I wanted to talk about that, but also your last point about involving a spouse, partner, family member, friend to give testimony. Can that testimony be in oral form?
Well, oftentimes, quite honestly, when we go to hearings or when we go to court, I don't mind that because there's adequate preparation. The last thing I want is for an insurance company to try to drive a wedge between my client and those people by miscommunicating what they're hearing. And that happens a lot. And if they test the waters and see that a spouse or a child or someone else is a weak witness, that does not help my client. So no matter how much you prepare people, and there are people who are exhausted living in a household where someone is this ill, and they use it as a gripe session, they use it. So honestly, I don't encourage that pre-litigation.
Okay.
What I do is we will sit down and we'll craft certifications based on what our client has told us and based on what they've told us. And we can edit out gripes. We can edit out, the negative rambling quotes. We wipe all that out and we edit it down so that the insurance company or the judge can see what sort of predicament the client is in.
So the way to go is if you have some other opinion about your condition and it's important for the case, go and have it certified by your attorney.
Yeah, the attorney can prepare a certification or a statement. We do that routinely. We do it in Social Security cases and we do it in ERISA cases.
Okay. Then another point before I get to the radiological evidence, what's the importance of CVs, performance evals, that sort of thing?
Yeah, that's important too. One of the things I tell people is they give me a CV and they think that that's the end of it as far as their work background goes, because Social Security requires that we document this person cannot perform the significant work activities that they've performed for the last 15 years. And in ERISA or in private disability cases, we have to document they cannot perform either or both their own occupation or any occupation. So when we are in that situation, a CV is not enough. And unfortunately, as much as I adore my corporate clients, they talk in corporate speak. You know, all the language that they've picked up over the years that corporate world loves. Judges in this context, insurance companies like, please, you know, can you lift? You know, what did you have to do in that job? So one of the things that I say to people, and my lawyers say to all of our clients, is if I had a camera following you around during the day, what would I see you doing? And what that does is it literally creates a visual of, for the judge, for the insurance company, for the doctor, for everyone to understand, okay, when I go into work, first thing I do is turn on my computer, then I put my headphones on, then I'm responding to 5 different time zones and, answering people's questions who are coming in. And then I have to get up and go to a meeting I have to prepare reports for my direct reports. That's the sort of detail we need to show it is impossible for this person to do those things because of this situation. And a doctor can look at it and say, oh my goodness, this person's lucky if they can get out of bed. They have 5 bad days a week and 2 good days. Never mind getting and sitting in front of a laptop for 10 hours with all these different time zones. So that's why it's critically important to flesh out. And a CV just doesn't do that. Now, what a CV will give you is an idea of the sort of work that this person did. A resume or a CV will just tell you the work history. They're not going to flesh out the work duties. I think that, as I said, it's a good starting point, but you got to flesh it out. And people get annoyed when I say, look, I need more detail. Why? I'm too tired. I don't want to. Then you know what? Write it out for me when you feel better.
Exactly.
And I'm sorry, the second component of that question was?
Well, so, the performance evals.
Performance evaluations are really important. Employers can be cagey though. Sometimes they'll have people do self-evaluations. Sometimes they'll show them the performance evaluation, but not give them a copy of it. So they'll know that their performance is being noticed by a superior, but they're not getting the evaluations. And good luck trying to get it from the employer. I mean, the employers do not want to walk into that because they're always afraid they're going to be implicated in a disability discrimination case. So while they are really important, if you can get your hands on them, I love it, but often you can't.
Okay, so you're not entitled to get a paper copy of your performance evaluation.
Not in my experience. Now, if it is an employment lawyer working on the case with me, I'll push them to try to get it. But they know. I mean, honestly, it's usually a discovery issue because employers just don't want to, particularly if it's a dramatic drop. Now, we won a case last year where the person did have a severe neurocognitive disorder. And we were able to get our hands on the performance evaluation, which I think won the case, to be honest with you. So if you can get your hands on it, it's great.
Okay. So try to get it.
Right.
So now to the neuroradiologic evidence. So as you were saying, MRIs, PET scans, SPECT scans, that kind of stuff is reported on in the literature and is also accepted by insurance companies as a reimbursable expenditure. What we have come up against is people are told by some providers to get what I call experimental procedures, such as functional MRI,
Right.
things of that nature, and are then surprised when it doesn't carry water. What's the story with that? Because it's very expensive to have these things done,
Right.
and then you provide the evidence and it's not evidence.
Right. Several years back, functional MRIs were a big deal. And my argument even then was, look, if there are other methods to document this, don't like spend money you don't have on tests that are really not going to be helpful. I mean, I'm very practical when it comes to things like this. I may push you to get tests that are expensive that you don't want to get, but there's a method to my madness. It's an investment. It's not wise to invest in things that don't really have much of a return. And the people if you're treating with people knowledgeable with ME/CFS and long COVID, they will know what those tests are. That's my 2 cents.
And so that's for the neuroradiologic stuff. How about lab tests that are, having results like some EBV things are looked at as scans. Some sort of more esoteric tests are looked at as scans, yet they're not covered by insurance and are expensive.
Right.
They're sold as, this is going to show that you have a marker for the illness. What should they do?
Well, I mean, again, my philosophy is very simple with this. If your doctor is pushing you to get it and they have expertise in this, then you may want to let them test you for it. If the doctor says, well, it didn't come back the way we thought it did, we still have to review that evidence. So my thing is, you want to always follow your doctor's lead. If your doctor is knowledgeable and experienced, listen to what your doctor says. Let the attorney worry about how to handle evidence. That's honestly, that's my philosophy on it.
Okay.
I mean, I've gotten into more than one disagreement with some doctors about tests that were being done or not being done and whether or not they were valid. And I never enjoyed being in that position, but I know what is out there in the journal world, and I know what helps my cases and my clients. So, and my associates are all of the same mind.
So even more important to have a capable lawyer in your court.
Yeah.
Next question, Barbara. So I understand the medical record stuff, and you said that there may not be all the records in the at least the electronic medical record, right, or the physical medical record. So how do I check, or do I need to check my medical records, or can I just forward them as they are, and how can I fix them?
Right. You never want to just tell your doctor, forward them to the insurance company, because as we gave the example we gave in one of my long COVID cases, I said to her, don't do it. And she said, well, won't that delay it? I said, please let me look at them first. Because she just didn't have the bandwidth to look at them. And she was a scientist herself. And so when I looked at them, I was like, oh my God, he literally wrote her up as a mental illness case and not a long COVID case. This woman had zero history with mental illness, and she was a very well-respected scientist at a young age and traveled the globe, with NGOs doing all kinds of impressive work. And this guy could have torpedoed it. Had he just sent it in, it would have been a nightmare. So I questioned her and I said, look, did you fail to disclose to me your mental health history? And she said, no, I don't have any mental health history. And I said, well, that's how he wrote you up. And she was livid. And I said, look, you have to go to him and you have to explain to him that this was not based on anything you said, and that he has to correct this in the record. Now, of course, removing something from the record is virtually impossible. So what he has to do is say, oh, either I confused her case with somebody else's, which of course getting a doctor to admit they made a mistake is not easy. Or what you want to do is have them write an addendum, which is this patient doesn't have a mental illness history. This was written in mistake. This was a mistake. And she did that, and he gave her grief because he didn't want to admit he made a mistake. And then she said, okay, then I'm going to have to report you to the head of the long COVID clinic. And then he suddenly realized he made a mistake. So it's never fun to have to go through that exercise, but it was really important because it would have totally torpedoed her case and limited someone in her 30s to 2 years worth of benefits when she was totally disabled from long COVID. Big mistake. And because of his bias.
So what my recommendation always is, when you have any appointments with any healthcare providers, go into the summary section of the patient portal or ask for a copy of the office note immediately, not 5 weeks later.
Right.
Immediately, so that it's fresh into in the healthcare provider's mind, and they can discuss with you how they're going to change it, why they don't need to change it, or whatever the issue is. But to rely on the notion that, oh, it's going to be okay, no.
And I have to say that, you know, for many of my clients and your patients, having the energy to do all that is really a challenge. So that's why I say, you know, if you want, give me or my paralegal your information, so for us to access it, we can look at it and we can see what's in there and let you know if anything is wrong.
Exactly. And also rely on your support system to get, you know, get a healthcare proxy going, have everything in line so that they can get on the phone with the provider and make your case.
Yeah, I mean, to even access the records, I have spouses looking at the records, sending them to us. I have friends that they trust to get access. You know, we get people to sign authorizations allowing us full access. So, you know, we explain to them, look, what's the difference between giving us access to the portal or giving us access via a general sign off, which gives us access to everything anyway. So, you know, but it's uncomfortable. It's a privacy issue.
It's uncomfortable, but it's crucial. It really extends. It also extends to medications. Right. Because I learned in all these years that insurance companies and also judges look at the medication lists that have been provided to them. And especially now with long COVID, a lot of people have received psychopharmacological medications, you know, especially early on in the pandemic, which is in their record and not explained often. So check the medications list, see what you're still taking, what can be taken off, what can be archived, and whether there is an explanation of any kind of psychotherapeutic why you're taking it, because some medications are used for pain instead of depression and so on and so forth. So all these explanations are really important.
Right. And the other thing I tell people is you can access your pharmaceutical record by asking your pharmacist for a pharmaceutical readout. We do that routinely and we submit it to the carrier.
Yeah, it's very important.
Right. And if they have any question, because we all know that there are certain antidepressants that are used to treat ME/CFS or long COVID symptoms that honestly don't have much to do with depression, then it's the pain centers that they're focusing on.
Exactly.
But an experienced physician can explain all that.
Exactly. So in the first segment, you were talking about the issue with previous medical disorders, the presence of those, and or psychiatric conditions.
Mhm.
Do I need to reveal that I have that pre-morbid history?
Yeah.
Or can I just sort of forget about it?
You have to reveal it. One, you should reveal it to any neuropsychologist or any other provider you're going to. And the reason you want to reveal it is, one of the things I say to people is, if you have a history, if you have OCD, if you have depression, if you have anxiety, if you have any of these things and were able to work all these years, that shows that that was not disabling to you. So we're dealing with something else here. The other thing is that certain conditions like OCD and anxiety, those people are some of the most productive and valued employees that employers have. And you'll see things like the performance evaluations you can get. I don't understand. This person would work 24 hours. This person worked without any sleep. This person would do all this and they were fabulous. I don't know what happened to them. And of course, there's Lenny Jason's argument many years ago about the fact that people, the differential diagnosis between ME/CFS and depression. You know, often people with depression can't motivate themselves to do anything, no matter what kind of antidepressant regimen they're on. People with ME/CFS or long COVID, on a good day, you can't stop them. They're like, whoopee, I can build the world. They're doing,
Which is the downfall too.
of course, and then they crash from post-exertional malaise. But motivation is not the issue. The
No.
issue is sustaining that ability to do those things. And that's
Exactly.
critically important. And you have to be, well, again, you have to be familiar with that to be able to make those arguments. Like, look, people with ME/CFS and long COVID kill themselves on good days. They outperform everybody and their mother. On bad days, they crash. And if the people with OCD and anxiety were the highest performers that were the employer had prior to them getting ME/CFS or long COVID. So that was not the reason for their disability. But that's why you cannot fear the truth. You have to understand it. And you have to be communicated, to be honest.
And to quote you from before, no gotcha moments.
Gotcha moments are the worst. I remember many years ago, a client of mine who didn't have ME/CFS or long COVID, but had something else, had a hand disorder and kept arguing that they couldn't use their dominant hand. They couldn't use their dominant, and the investigator for the insurance company, because they're sneaky devils, followed the guy into a restaurant and saw him using a knife and fork with his dominant hand pretty easily and sent me the video footage. Now, usually the video footage that insurance companies send me proves my client's case. You know, they'll have an ME/CFS or long COVID person doing a million things on a good day, and then they won't video capture them for another 2 weeks. Why? Because the person never left their house. But in this case, it was deadly. And I said to the guy, why did you lie about that? And he said, well, I didn't know. And the investigator, who, you know, I had been dealing with for quite a while, said, Barb, nothing better than a gotcha moment. So you always have, even if you have days where maybe your hand is really bad, and then there's 1 day or 2 days a week where you have more use of it, you have to tell the lawyer or the insurance company that, because you don't want the gotcha moment to destroy the case, because there is nothing that impresses judges more than, you know, the woman doing backflips on the front lawn who says that she can't walk. So you have to be honest.
Yep.
And if your lawyer is good, the lawyer will be honest with you and say to you, look, this isn't going to fly. This isn't, or we can explain that because you have good and bad days. And that good and bad days is a very crucial thing, which is why journaling is so important, because you want to document that on a good day, you know, the world is your oyster and you try to push yourself to do everything under the sun. On a bad day, getting off the couch or out of bed is a struggle.
Yeah. I use that good day, bad day approach after neuropsych evaluations to
Oh, yeah.
show that even, you know, if you do them remotely for 2-3 hours over a few days, you're going to be most likely paying for it. And then I include the record verbatim in the report.
Yep.
So, you know, it's really, really helpful.
Yeah.
All right. So the next question, I think you answered that one already. How do I go about finding a physician or clinical neuropsychologist who specializes in ME/CFS and or long COVID? What are the most important items to concentrate on? And you just raised the flag that if that person is not able to complete the appropriate paperwork,
Right.
move on.
Yeah, I mean, it could be the best doctor in the world. And there's not that we're not saying you have to abandon that doctor, but you have to have a doctor who is knowledgeable alongside of that person who is willing to complete the paperwork. Because without responding to and insurance companies know this, by the way, and they know they don't just accept medical records. They don't do that because they want to aggravate the treating doctor and they want to aggravate them. So they say, I'm not doing this anymore. This is too aggravating. And it works with a lot of doctors. So if a doctor says, look, I'm not filling out this paperwork, go find somebody else. You know what they say about bad boyfriends when they tell you who they are, you should listen. Same is holds true with the doctor.
Thank you, Barbara.
Okay.
All right, so now I've put the claim in, I got a lawyer, I get a letter of denial. What should I do?
Well, I mean, first thing you do is if it's an ERISA long-term disability insurance case, you have to immediately request the claim file. They have 30 days to produce it. And you could flip through it if you have the energy to see what some of the dirty deeds they did. But that's when hiring a long-term disability ERISA specialist or a disability insurance specialist is really, really, really crucial. Because they will know what needs to be done to document the improper procedural and biased behavior that the insurance company engaged in, assuming they did, and often they do. So that's really important. And also that lawyer then has to find out what the weaknesses are in your case. They will review the case. They will look and see what the insurance company thinks of your case. They will look at the credentials of either the nurse or the other reviewers who participated in the case. The Code of Federal Regulations that governs these ERISA long-term disability insurance claims will also be familiar to that lawyer, and that lawyer will know how to punch holes in all the procedural improprieties they engaged in. The lawyer will also know what they need to produce medically to document the case if it hasn't been done already. And then they will know how to legally argue your case. Because remember, I can tell you, at least from my office, when we do the appeals, we're not just doing the appeals for the eyes of the insurance company. We're doing these appeals for a judge. Because ultimately, if the case gets denied, the judge's clerk and the judge are going to be reading this. And we want to appeal to them just to show how bad the conduct was here, how this person was denied a full and fair review, how this decision was not based on substantial evidence of records, and why all the code provisions they violated, all the legal decisions that gave guidance were violated. And that's why you need to get somebody who knows what they're doing, because they'll know how to navigate. It makes all the difference, honestly.
So you get the denial letter, get a lawyer, an ERISA lawyer or an experienced person, ASAP.
Yep.
So now you got that lawyer, you are on disability. We are getting to segment number 3.
Mm-hmm. Okay.
Okay, so now we are on the third segment and the final segment of our webinar. You are on disability. So I filed for LTD, Barbara, LTD benefits under an ERISA group STD LTD plan. Why did the insurer insist I file for Social Security disability? And should I use the SS vendor they offer? I know you touched on this before,
did.
so.
We did. I mean, I basically covered it before, but long and short of it is, in my opinion, there's an inherent conflict of interest in using an insurer vendor to argue the case for you when there's a vested interest on the part of the long-term disability insurer to project the case, particularly ME/CFS or long COVID case, as a mental illness as opposed to a physical illness. So they only have to pay for 2 years as opposed to the full duration of the policy to full retirement age. Also, some of these vendors are not even lawyers. They are probably experienced in doing these cases, but they're not subject to the code of ethics that lawyers are. Also, most ERISA LTD policies contain the mental health limitations, which we talked about. You know, if they only have to pay for 2 years as opposed to 30 years, guess what? They're going to try to get that vendor to argue the case for Social Security like that, and then they can use that when they argue in front of a judge. You are also not required to use their vendors. They pitch these cases to people who are on these benefits as basically implying they're required to use their vendors. You are not. There is nothing in any of these policies that requires you to use their vendors, no matter how they try to slant it. And Gudrun, I think we're at the last question.
We are at the last question. So I got my disability. Big sigh of relief. Barbara, am I home free now once I've been approved
Never.
for Social Security
Churchill said.
disability, or get my LTD insurer to pay my claim either initially or following appeal? Can I put myself to rest?
No, Social Security is an obligation by statute to continue to review your case between 1 year and 3 years after you're approved, just to try to save the federal government money. So you can anticipate that. When you get those forms, if you get the short form, which basically doesn't ask for much more than your disability and your name and address, you can do that yourself. If they send you one of the long forms, get a Social Security disability expert attorney, because they're complicated, and it looks, when they send those long forms out, you know they're targeting you to try to terminate the case. They have to prove that your disability has not only improved, but that it's improved sufficiently for you to return to work and perform substantial gainful activities. You want to keep following up on doctor recommendations for that reason, because people will say, "No, I don't have to go to the doctor. Because everybody hates going to the doctor. Yeah, I don't want to have to go to the doctor. It's expensive and it's a pain." And continue to go as the doctor recommends you should go. So if it's once a year, that's fine. Twice a year, that's fine. Also, with respect to long-term disability, until the case either reaches the full duration of the policy, age 65 or full retirement age, or you have settled the case in litigation, be prepared to be reviewed, have them ask to meet with you, to ask questions. Always do it with your attorney present, and to complete forms, and don't take it cavalierly. So you want to continue with those doctor visits for those reasons, and you want to continue to document the case for as long as the case is active, either Social Security disability or the long-term disability policy. And that's
Barbara, does that also include a surveillance?
Well, they do surveillance all the time. It's cheaper to hire somebody to do surveillance, to watch everything you do. But again, if you're honest in how you complete your responses to these forms, and you're honest in response to what the insurance carrier asks you, you have nothing to fear.
Okay. Well, that's the end of our webinar. I hope it was useful.
I do as well. And Linda, thank you for giving us this opportunity.
Thank you, Linda.
Try to bring some light to this very upsetting and challenging situation.